morning, fellow Cameroonians. I guess this is a new one. We will be addressing all Cameroonians, henceforth Anglophones and Francophones. So good morning, in particularly to our Ambazonian, Southern Cameroonians, as you may choose to call yourself. Henceforth, we'll be addressing all Cameroonians, including Southern Cameroonians in our podcast. Good morning. Today is 19th day, Tuesday of this month of August 2025. My name is Capo Daniel, Chairman of PRAP. This is our daily podcast, a program where we present to you the truth, fact, analysis of relevant information for your information and empowerment. You are welcome to this platform. Ladies and gentlemen, our mommy them, our papa them across the globe, we want to salute una all from PRAP and for bring una our daily podcast. It don't be a long time when we put out a podcast, but today we put out our daily podcast in a new format, hoping that we will address all audience, because we have ignoring Francophones does not help us in any way. So today in our podcast, AKERE MUNA sues Paul Biya in Cameroon Constitutional Bench, that is the Constitutional Council, a bench of the Cameroon Supreme Court. AKERE MUNA then filed a lawsuit saying me then deny Paul Biya in eligibility. That means say me the Constitutional Council it do for Paul Biya, which way they don't do am too for Maurice Kamto. We go get into the petition detailedly. We then get the complete file, including attached evidence, and we then submit them for the Supreme Court. We go to talk for good English more and they mix them for pidgin, so that make all man a day for Southern Cameroon in particular when our core immediately understand where to the talk am. So I will give una a summary for the petition where AKERE MUNA, Barrister AKERE MUNA, Tambeng, it then file am. This day it file am on the 12th of October. This month October, I want to correct the date for the podcast. It file am on the 12th of October, this 2025. For the ground, the law where he use them for file this court case, na Article 118 for Cameroon electoral law, where he disqualify any person who by his own doing has placed themselves in a situation of dependence on or convenience or convenance with a foreign person, organization, or power. That means say for this article 118, it talks say any man where he did for a situation or he don't put a situation where he depend on a foreign person, organization, or power for leave and for take decision them, that person in need for be disqualified. The core argument where AKERE MUNA make am for this document for court na say Paul Biya will be age at 92 years old due to his age and a reliance for foreign medical help, especially for Switzerland, as the document quote am. It don't make Paul Biya life be dependent on a foreign body, and he no go fit perform his presidential duties without those medical help them where he get them from hospital where they for Switzerland, as AKERE MUNA a document then quote am. According to the argument where AKERE MUNA they make am, Paul Biya put himself in a dependence according to that article 118. He then put himself dependence on the Switzerland, their hospitals, for leave and for carry out the presidential duty. So he need to be disqualified according to that law where it talks say man no fit be dependent on a foreign body, a foreign again a three qualification, a foreign body, a foreign power, foreign organization or person for carry out the presidential duty. The second argument we make and I say governance has been effectively delegated to unelected proxies, as confirmed with the document we cite and where the Minister of Justice it then released on document where it talks Paul Biya be transferred some power for Ferdinand Gongo, according to the argument we AKERE MUNA the make and for court na say governance now where Paul Biya the govern Cameroon, it govern through other people them we then delegate power for them. And that evidence where they then submit as some document where Minister of Justice it be talk am. The other third argument where Akere Muna make na say Paul Biya medical dependence on a foreign doctors constitute both external influence and incapacity to govern. So Paul Biya did rely now on this foreign doctor them. It mean na say Paul Biya ability for rule it be influenced by this doctor and this medical situation where they inside. So now the three argument that way Akere Muna he then put them for front that constitutional council. Which way Akere Muna request them. So that one now the summary for the argument we put them. For the documents them, which way it requests from the Constitutional Court. Akere Muna requests 3 actions, legal action, the Constitutional Court take them against Paul Biya. 1, then declare say Paul Biya be ineligible under Article 118. So then talk say Paul Biya enough be presidential candidate because he did rely on the foreign doctor them for Switzerland as he talk him, and given the age. And also the point say, Paul Biya the rule nana by delegation. That means say they give power for other people then for use them. The second request, legal remedy where Akere Muna request them for the Constitutional Council. Now say, then compel personal appearance before the Constitutional Council or production of a medical report by an independent expert. That means say the Constitutional Council give an order. Say me Paul Biya come appear for that Constitutional Council their front so that me then see say he be independent. The second action I say me then ask me Paul Biya go for independent doctor where he be independent from foreign government, make he give document medical certificate say Paul Biya he dey medically fit for he govern without any foreign reliance. Number 3 action where Akere Muna he ask him for this court we then file him for court. Now, say me they apply Article 128. Article 128 now an article where the Cameroon Constitution if he force political party they me then replaced their political candidate for presidential election if they don't already accept their submission but then reject the candidate. They first give the party 3 days for choose another candidate. So these are the legal remedy where Akere Muna they ask him for that court. Now, where to be the legal basis them for this and case where Akere Muna it put them, where to be the standing based on our own legal examination on the case we will give una which will say it happen and how the court it will see them. According to the court, Akere Muna be eligible for file the case. That means Akere Muna, if you put this case for court, they go listen them because they need for it be qualified. When you submit this case for this application, the court get 3 days for make decision after they don't file this court case. Akere Muna be na a direct interest. That means na a presidential candidate. So he be a person of interest for this matter and he get right for file this case. The Supreme Court and Cameroon Constitution get time limit for file this case. That means if you file them anytime. But based on the date we did for this document, it shows that he never submit the document yet for court. He intend for submit them. The date for they been at 12th of October. So, but if you file them any day, the court will get 3 days for give their decision on those 3 points and we then ask them if in case it be valid by the court. Now, what is the interpretation of the article where Akere Muna then use them for file this case? He file them based on Article 118. Wait till that article actually talk them. It be important for our people to know the interpretation for this law for Cameroon, the electoral code. The law, it will be designed for prevent any foreign manipulation of candidate for stand for presidential election for Cameroon. So Akere Muna, he don't see this one. He try for stretch the definition of dependence because the court talk say no person of it be presidential candidate will be dependent on a foreign body, organization, or person or power. So Akere Muna he try for use Paul Biya in medical situation, say they rely and need to use not only foreign doctor them for talk say then get influence over it. Also, you get the issue of cognitive and physical dependence on it. That means say if you be so weak, so powerless when you rely on many people and carry you, you be function, if you function on your own, you also feel be disqualified under this article. Also, this article, it talks say if you govern by proxy. That means say you must be able to be president and exercise your duty by yourself. No be for give power for other people them. So that is the intent of that law. Wait support this law, the court cases, the way quote them for a case for support them. Now case for Hayden case for 1584 for France, where they be then interpret them say person in medical condition where if he be considered as mischief, doctor if he manipulate person. That kind of case it be done happen for France. You also get comparative law where they talk about disability and abuse of weakness doctrine. The French Civil Code, it for French people, their law for Civil Act 1143. That means say if some person you be so weak or you be disabled, people then feel abuse you. So if you be a president, if you be disabled for the way that if you be abused. So if Paul Biya be so old, the argument that say this law it can be used for France also for disqualified person. The interpretation also, if it come positively about the analogy of private guardianship, that means that the head of state cannot exercise for sovereignty if he is constantly being controlled by others. That means if Paul Biya be controlled by other people, then he will also be disqualified. So the strength for this case now the use of Paul Biya age, in medical situation, and document the way he says it and sign for delegate power to other people them. And if it be a legal interpretation, I say if you use sovereignty for a government when if it exercise them on your own. So if you even first apply, say you want to be a president, if you use that power by your own. The only weakness now say he rely on foreign doctrine them for civil law, will be right, but the Cameroon Constitutional Council or Cameroon Court has never interpreted this Article 118 for a broad way. So we not get that historic basis of such interpretation. And literally, it always defers to the incumbency. So they will always favor people waiting there for power. So, but the evidence, the way AKERE MUNA is cited, the public absence from election submission. It talks about Paul Biya be present for submitting candidature. AKERE MUNA also make a very powerful point. Say Paul Biya a party congress where they be shut down for decide their presidential candidate. Paul Biya says be attend them. Judiciary meetings them for CPDM and also involving CPDM issues. Paul Biya did not attend. So how person way even attend meeting the way they decide candidate? Person way attend judicial meetings them. Person way submit your own application. How they would allow that person for become a presidential candidate? AKERE MUNA also cite say Paul Biya be disoriented. That means say be confused for the African Summit where be take place for 2022 where Paul Biya be ask and say where was he? He be recorded on tape. AKERE MUNA also put and say those are very powerful points for sure say Paul Biya be physically fit. It depend on other people than for govern. He also signs on document for 2024 where the Justice Ministry Jonah where he admit impostures and unlawful injunction submission against presidential will, where it shows that people the way Paul Biya be give them power, then use the power for the way be want them, and therefore inside ministry their own Jonah. AKERE MUNA also bring the point where Paul Biya be stay out of the country for 42 days for 2024, say that prolonged stay abroad in absentia, even when people they be asked his whereabout, also show say na evidence for incapacity for Paul Biya for become a presidential candidate or seek another new mandate. AKERE MUNA also submit well-documented systemic governance by unelected proxies at the Unity Palace. So this is a very powerful case submitted by AKERE MUNA against Paul Biya. This is a powerful challenge. It established factual narrative of incapacity and foreign dependence in a logical mind that every Cameroonian should know that these are facts that has been submitted in court by a credible person in the person of Barrister AKERE MUNA. The challenge is that the Constitutional Council may dismiss it as political argument not as judicial provable, because for you to declare somebody incapacitated, you need medical proof. But AKERE MUNA, a case, he done brilliantly see this loophole them. Now, right away, ask for remedy for the court for force Paul Biya for appear personally before the Constitutional Council or submit medical file. Those are legally sound remedies that AKERE MUNA have put outside, which are not political. These are physical, these are provable things that he has demanded. The Article 128, as also where AKERE MUNA then put them like a remedy, allow the Constitutional Council for disqualify a candidate and given that same political parties 3 days to file in another candidate for avoid institutional vacuum, which makes it not a political issue, but indeed an honest attempt for justice for the peoples of Cameroon. So the fact that AKERE MUNA requested me the CPDM replace Paul Biya, strengthen its petition's responsible tune. So what are the prospects for this submission, this writ that has been submitted to succeed, or that will be submitted to succeed? The people have to understand, this is why the failure of Maurice Kamto have really helped Paul Biya and negatively affect any chances of change in Cameroon. You need public mass protest, mass public display of interest in overthrow or replacing or challenging Paul Biya, which is absent in Cameroon. There was not massive protest, massive rallying of Cameroonians to demonstrate their opposition to the regime and to demand change. This failure have left a very big vacuum and lack of pressure on the institutions that are making such decisions. So the council can reject this petition without any fear of sparking organized or massive street protests from Cameroonians, because the context of our political convenience is very, very important. This context is very important. All judgment made by this court have always been pro-incumbents. So there is always pro-incumbent bias by this court. The reality is that it will be very difficult for the court to interpret dependents to be medical or physical incapacitated or governing by proxy, because the law intends to prevent foreign governments, organizations, and personality from controlling Cameroon's president or candidates that are running for presidential election. They didn't envisage medical situation or physical inability to appear or perform duties in that law. It was specifically designed to protect foreign government from interfering in Cameroon elections. So it will be a tough chance to convince a biased court to take a favorable decision. But there are some moderate chances that if we had international pressure, domestic pressure about fairness, that some result could happen. But there is lack of that thereof. The political reality is that the Constitutional Council do not have people like Justice Paul. They are all people who were classmates. The head was a classmate or a childhood friend of Paul Biya and his allies. There is no historical ruling in that court that may make somebody to believe that they can ever take any decision independently from what the CPDM regime wants. All the statements made by the judges in that court are always against opposition, and they are always in accommodating of the ruling regime in place. So if inadmissible argument could be made, most likely outcome will be that the petition will be dismissed as unfounded. But this petition alone, this court alone, and the fact that this Constitutional Council is supposed to be an open court where journalists are allowed and the public are allowed, is a very good strategy by Barrister AKERE MUNA. It will highlight to the public that government by proxy is going on in Cameroon, and it lacks transparency and risk foreign medical dependence. It will also show international advocacy that create on the record and by observers, human rights observers and groups and foreign government, to observe that this case that has been made against Paul Biya have real articulation behind, have real narrative behind. So whether it has a chance to succeed or not, this is a very brilliant idea of AKERE MUNA to bring Paul Biya in the public ask the court to call Paul Biya to come to court, and we will see whether they can do that. If they fail to do that, if a powerful case is made in the public, it will be a big blow to the morale and standing of the Paul Biya's regime in the eyes of all Cameroonians. I must admit that legally, the petition is well argued, but will face systemic judicial resistance, as we all expect. The most realistic outcome is that it will be rejected. However, it is political and adds a lot of advocacy value. It's very, very significant. It put Paul Biya health, foreign medical dependence, and governance by proxy officials on the record, and for public scrutiny and international scrutiny. So this is a very powerful and brilliant move by AKERE MUNA. Once again, where is the popular support? Where is the public demonstration to back the move against Paul Biya? Capo Daniel, looking out for you, signing off.